Bill Henshaw here for the Constitutional Crisis Channel again. Today's subject is the IRS policy on frivolous claims, quote unquote. And they're real big on this. I'm going to have on the website before too long a policy statement document of the IRS on this subject, where they think, and they frequently do, fine quote unquote taxpayers, $5,000 or even more, for bringing frivolous actions in court to try to challenge the IRS. Now, as I mentioned on an earlier video, a lot of this power goes back to Section 4 of the 14th War Amendment. We're not going to go over it here, but, where they think that since you accepted their citizenship, they own you, and you can't question the validity of the public debt. That said, they're either stupid enough not to realize that they're making the case here for states against territories, or they think that the American public has been sufficiently immunized by the mandatory public school system that they're not going to get it even if it comes to their attention. Because I agree with them. You go into a tax court, quote unquote, you can't go in there and make a claim that you're not a quote unquote person, quote unquote employee, quote unquote taxpayer, or what have you, because those subject matters are really not specious and frivolous. What they are is beyond the jurisdiction of that administrative tribunal to rule on. If they were honest about it, that's what they'd be telling you, but then that lets the cat out of the bag now, doesn't it? So that said, we're in a system in which the Constitution says we have the right to a judicial court in the first instance. We don't have to go through one of those BS administrative tribunals to get there. We go right to a judicial court, right to a trial by jury if necessary. And if we do that, the government then has to prove each and every element of the crime in order to get a conviction. Good cases on this are Morrisette versus United States, 342 U.S. 246, I believe, and Re Winship, W-I-N-S-H-I-P, 397 U.S. 358, where the Supreme Court has flat out said they've got to prove each and every element. Well, the fact that you're a quote-unquote person is most definitely an element, and the IRS takes great umbrage at those who come into their courts and attempt to raise that. Comes under 26 U.S.C. 7701A14. Well, you're right to do it. It's just that we're not in the right forum to make that argument, and it's something that they should have the decency and integrity, not to mention oath of office, to tell you that you're in the wrong place, but obviously they never do it. So we get that, and we get other things in the Internal Revenue Code that people aren't aware of, like 26 U.S.C. 6305B, that says that no court of the United States, whether authorized under Article 1 or Article 3, shall have jurisdiction to review or restrain the collection of taxes assessed by the Secretary, unquote. That, by the way, is the Secretary of HHS these days. It was Health, Education, and Welfare earlier. And that's apparently a waiver of the entirety of your rights to invoke the judicial power of the United States. Not so if you know what you're doing and what you're reading, but that's what it looks like. And if that's the case, then the entirety of the Internal Revenue Code would be a bill of attainder. They're not taking a property without judicial process. And I would love to get that question before the Supreme Court of the United States, or better yet, an inflamed jury. And we'll just see how that one comes out, because they flat out have no authority. But this is what they want to mislead the American people into believing. And then you look deeper and you find out that you become a quote-unquote person, a quote-unquote taxpayer, which is 26 U.S.C. 6109A, and a quote-unquote individual if you make an application for Social Insecurity benefits. That process is 100% voluntary. I have my own personalized letter from the then Commissioner of Social Insecurity, Dorcas Hardy, admitting it. This will show up on the website and the Facebook page in the fullness of time. Yes, it's voluntary. You don't have to make application for it. And these waivers that you see in the Internal Revenue Code are among the reasons why. And again, with waivers, we talked about this earlier, that the Supreme Court says they've got to be voluntary, knowing, and intelligent. But at no time in the entirety of the application process for Social Insecurity does the government tell you any of this. That's fraud. It makes it null and void on its face. And what it also does, if you do get into a trial with the IRS and they attempt to assert any claims against you by any witnesses, it makes all of those claims irrelevant, incompetent, and immaterial for lack of foundation. They defrauded you into the system. They cannot take advantage of that unlawful act. So this is the sort of thing, I mean, the IRS, as it often does, it tells half the truth, if that. But this is why they get so upset about this, because once somebody uncovers the truth about this and gets it into the right form, whether it's the Supreme Court of the United States or wherever, and gets the issue decided, bang, they're done. One win across the board. It's going to take away all that power, except in the case of artificial corporate entities, and maybe they have power over those subjects. Not one that I care much about at this point. But nevertheless, we get into the ballgame here, and we're going to put them out of it. Now, continuing with the matter of IRS policies and the deceits they've waste off on us, what you find out is if you make a timely objection, and this is amazing that this happened. I think I mentioned this case earlier, but it's worth repeating because case is Gary Bass versus United States, 784 Federal 2nd, 1282. And during the course of his trial, quote-unquote, for tax crimes, the judge, quote-unquote, effectively instructed the jury that Bass was an employee, quote-unquote, within the meaning of 26 U.S.C. 3401C. Bass timely objected, and or his attorney did so, which is amazing if it was the latter, preserved the objection, got to the Sixth Circuit Court of Appeals in Texas, and got the case reversed because the judge instructed the jury on an element of the crime, which is exactly what you should expect in a judicial court. I don't think they were in one, but that's a different story for another day. Nevertheless, it got reversed. As far as I know, Bass was never retried, because if you read 26 U.S.C. 3401C and you find out what an employee is, you find out that you're not one. It talks about officers and employees of the United States or of a corporation. And this makes sense because with the Internal Revenue Code, if you're getting benefits from the government, then you owe them obligations, and those benefits are internal to the United States government, and I believe they are taxable pursuant to Article 1, Section 8, Clause 17 of the Constitution of the United States that gives Congress a lot of powers in the District of Columbia. And you'll find this also in the Internal Revenue Code, 26 U.S.C. 7408D, which says, in effect, that a taxpayer and or his residence, quote-unquote, can be found, if not in a state judicial district, can be found for all purposes in the District of Columbia. That makes perfect sense to me because that's where the tax is valid. It could be valid in insular territorial possessions, and if that's what the states have been relegated to, then they think they have the power here too, but they would also be forced to admit that they think, for example, the state of California is the District of Columbia also, and they're not going to do it. They just cannot afford to do that. Even old Joe Sixpack on the corner will wake up and say, what the hell is going on here if they do that? They can't do it, they won't do it. I'm going to try to force it anyway. So we'll see how that goes. Thank you.